My dear student, welcome to our class. I am Arabia Khanum, lecturer law, School of Social Science, Humanities and Languages, Bangladesh Open University. How are you, my dear student? Fine? Okay, we are fine also. This is Mr. Muntasir Mahmood Rahman, practicing lawyer. Today, we will hold class on Muslim law, and by this class, we will learn Islamic law of succession. By this class, we will learn what is inheritance, what was the condition in pre-Islamic Arabian customs, and what kind of reformations have been made by the Islamic law, and different kinds of the sharer of the Muslim law. Now, let's start our class. Okay, Mr. Muntasir Mahmood Rahman, would you please highlight actually what do you mean by the Islamic law of inheritance?
Thank you, Arabia. Inheritance is a method by which the property of a deceased person is distributed among the sharers, and successors of that particular deceased person. Inheritance or succession is prevalent in every legal system. So in the Muslim law too, Muslim legal system too. In Muslim law, the specific mentions about the shares and rates of property to be has been mentioned in the Quran, Sunnah, and Ijma and Qiyas. This is called the Islamic law of succession. Muslim law of succession is a very much well appreciated and systematic method, and this is the system by which the property of a deceased Muslim male or female is distributed among his or her heirs and successor in interest. The Muslim law of inheritance has been found in the source of Quran Sharif, in the source of Hadith, Ijma and Qiyas. This is all about Muslim law of inheritance.
Thank you, Mr. Muntasir Mahmood Rahman. I have another question, that is, what is the condition in pre-Islamic Arabian custom in respect of inheritance?
Thank you very much. Pre-Islamic Arabic society, we all know, the time was a time of darkness and ignorance. It is popularly called as Ayam-e-Jahiliyat. Yeah. And in that period, there was no specific law or rules regarding succession or inheritance. Especially the people used to deal with their inheritance and succession by way of customary rules. There was no specified system by which a person can be benefited from his ancestors, or he can give benefit to his predecessor. People in the pre-Islamic society used to do everything by their caprice and whims. But there were two specific rules among the unspecifications, that is, the nearer male agnate got the entire property, excluding all the relatives or any other sharers. And most important factor was that no female or girl was entitled to any kind of property. The right of female, right of girl were totally excluded in the pre-Islamic customary system.
Yeah.
That was the condition there.
Yeah, thank you, Mr. Muntasir Mahmood Rahman. And now, would you please tell us what kind of reformations have been made by the Islamic law?
Well, thank you very much. Islamic law, after the inclusion and invention of Islam, and after the preaching of Islam by our Prophet, there were tremendous development in the field of Islamic law, and in the Islamic law of succession has gone through so many changes. Especially the right of the women has been introduced in the Islamic law of succession, and the right of female in the property was introduced, whether she is the wife or she is the girl child. She was entitled to the specific part of property from his husband or father. And another most important factor was that the right of widow was also introduced. If any female person alive when her husband dies, she is entitled to get some kind of property. And another 2 points is that the rights of the parents were included, and some new list of successors were also included in the list of the succession. So Islam had brought about so many changes and outstanding improvements in the field of inheritance after 640.
Okay, thank you, Mr. Muntasir.
Arbi, I have one question for you. Would you please answer the question? What are the classifications of heirs in the Islamic law?
There are three kind of heirs in Islamic law. Number one, sharers. Number two, residuary. Number three, distant kindred. And a sharer are those heirs who are entitled to prescribed property from the heritable property. And a residuary are those heirs who only who will only get the residue of the property after exhausting the Quranic heirs. Distant kindreds are those heirs who are related to the propositors by blood, but they are not included in the list of the sharers. A sharer actually means whose shares is specifically mentioned in the Quran. They are the first category of the sharers. They will get the property in order of priority, and their share is specifically mentioned and allotted in the Quran. In this case, I want to cite the most popular Arabic term, the al-furd, which means the holder of the shares, the holder of the specific share of the property.
Thank you. So, how many members constitute the sharers?
Actually, there are 12 in number. The husband, wife, father, mother, daughter, son's daughter, to grandfather, to grandmother, a full sister, consanguine sister, uterine brother, and uterine sister. In this case, I want to mention that among these 12 heirs, to grandfather, to grandmother, and son's daughter, their shares are not explicitly mentioned in the Quran, but they have been added in the list of the sharers by qiyas.
By qiyas. Thank you very much. So, is there any classifications in the sharers?
The sharers may be classified from three dimensions. Number one, classification based on gender. Number two, classification based on the source of relationship. And number three, classification based on exclusion. And classification based on gender, that means female or male. And the number of female heirs is more than the male members in the category of the sharers. In this case, there are full male members. They are the husband, father, to grandfather, and uterine brother. The rest 8 are female members in the category of the sharers. And classification based on the source of relationship, in this case, they may be classified by affinity and by blood. By affinity, the affinity arises actually by marrying each other, as for example, husband and wife. And by blood, the relationship may be classified in this case from 3 dimensions. Number 1, ascendant. Number 2, descendant. Number 3, collateral. In this case, I want to explain actually who are ascendant, who are descendant, and who are collateral. Ascendants who are in the higher degree actually from the propositors, and descendants means who are lower degree from the propositors, and collateral means ascendant of the descendant of the deceased persons. And ascendant, they are 4 in number, the father, mother, to grandfather, and to grandmother. Descendants, there are 2 in number. Number 1, daughter. Number 2, son's daughter. And collateral, there are 4 in number. So, a full sister, consanguine sister, uterine sister, and uterine brother. A classification based on the rules of exclusion. In this case, I want to cite who are totally excluded and who are not totally excluded. And at first, I want to cite actually who will never be excluded from the list of the sharer. In this case, husband, wife, father, mother, and daughter. And who will be excluded under any circumstances? In this case, to grandfather, to grandmother, son's daughter, full sister, uterine brother and sister may be cited. Okay?
Thank you very much. We just learned about the classifications of sharers. Now, I have another question for you, that is, the portion of husband and wife is very much important. Would you please focus on the portion of the husband and wife, who gets what portion?
Actually, in this case, I want to cite a very, very important verse of the Quran from Surah Al-Nisa, ayat number 12. where it is said that that in watching wife leave, your share will be half if they leave any child, and your share will be reduced from half to 1/4 if they leave any child.
So we just learned about the classifications of shares. So I have another question for you. What are the portions of husband and wife? These are very important in our society, the portion of husband and wife. Would you please focus on that?
Husband actually is the primary heir. He will never be excluded under any circumstances. The only condition is that the wife must die during the continuance or due to the subsistence of the marital tie. In this case, I want to cite a very important verse of the Quran from Surah Al-Nisa, ayat number 12, where it is stated that in what your wives leave, your share will be half if they leave no child. If they leave any child, your share will be reduced from half to 1/4. There are two situations in which case the husband will get the property. Number one, he will get half of the property when the deceased leave no child and child of a son. And he will get 1/4 of the property when the deceased leave any child or child of a son. In this case, I want to cite the child who will be included in the list of the child. Child means son and daughter, and child of a son means sons, daughter, son, how low soever.
You just mentioned about the child. So will you please focus the child of whom it is?
Actually, in this case, it is immaterial whether he is the child of the husband or not. It will suffice if he is the child of his wife. It is immaterial who is the father of the child. It doesn't matter actually whether he is the child of his husband or not. It will suffice if he is the child of his wife. It is immaterial who is the father of that child.
So thank you very much. I have the last question for you. Is there any exclusion rule regarding the property distribution of husband and wife?
Under no circumstances husband will be excluded. In this case, there is a rules of exclusion, that is partial exclusion. If the proprietor leaves any child, his share only be reduced from half to 1/4. Under no circumstances he will be excluded from inheritance. There are two situations in which case the wife will get the property. Number one, the wife will get 1/8 of the property if the proprietors leave any child and child of a son, and she will get 1/4 of the property if the proprietors leave no child and child of a son. Okay.
Thank you. Is there any special rule regarding divorce?
There is a special rules in case of divorce, in which case the only one condition is that the wife must die during the iddat period, and the divorce must be revocable divorce. In case of revocable divorce, the husband will get the property. In all other forms of divorce, he will get nothing from his wife. My dear student, this is all about today's lecture. If you have any question, you can contact with the Dean, School of Social Science, Humanities and Languages, Bangladesh Open University, Gazipur 1705. Thank you very much for staying with us. See you in the next class. Stay fine.